5.
Right, I think we're now live. Good afternoon, everyone, and welcome to this UCL Minds lunch or lecture. I'm very glad that people have been able to join us for this today. My name's Aidan O'Neill. I'm a practicing lawyer at the English and Scottish bars. I practice primarily in constitutional law, who knew there was such a specialism, and EU law. I'm an old friend of our speaker today, Oliver Gerstenberg. We were both fellows in the Law and Public Affairs programme at Princeton, although at separate times. We share, I think, an interest and a background, actually, although in the interrelationship between law and philosophy. That was certainly my main interest as an undergraduate and postgraduate, coming from a Scottish constitutional tradition and philosophical tradition under Neil McCormick. Oliver coming from a Germanic tradition under really working with Jürgen Habermas. Oliver is a well-known, well-renowned EU lawyer, a constitutional lawyer, interested, as I say, in legal philosophy and the bigger questions, really. He has, his most recent monograph is Euro-constitutionalism and its discontents, which was published by OEP just 2 years ago. He holds a position as a senior lecturer at UCL and is involved in European Law Institute project on fundamental constitutional principles in the EU. He's previously held a JF Kennedy Fellowship at Harvard University, was a LAPA Fellow at Princeton, as I've mentioned before, as was I, and has a doctorate from the Goethe University in Frankfurt. Oliver's going to speak to us in this, today on really the issues arising out of the post-Brexit EU response to the COVID pandemic, in particular, the idea of the European Union itself being authorised to borrow money on the financial markets as part of its own resources to respond to COVID, and the constitutional issues which have arisen from that, particularly from the German perspective. As we know, the Bundesverfassungsgericht, which is a word I always like to get in any court appearance I'm ever in, has, in some sense, has been the guardian or self-presenting guardian of the European Court of Justice to make sure it sticks to fundamental rights notions properly, and also properly respects, as the German courts see it, the constitutional traditions of the member states. And Oliver's going to talk to us about those tensions between those two concepts of supranationalism and national constitutionalism. He's going to talk for about 30 or 40 minutes. There is a possibility of asking questions. That's done on the slido.sli.do program, which allows you to type in questions as they occur to you. And they will come up. You can vote on them if you think they're particularly good. And at the end of Oliver's presentation, I will read out such questions as we have, and we'll see where we go from there. Okay, with that introduction, I will mute myself and hand over to Oliver. Thank you.
Good, thank you very much. Hello, everybody, and thank you in particular to Aidan for your generous introduction and for being here. As you said, we know each other for quite a while and share a lot of interests. And thanks also to Matt and Sandy for being in the background and making sure that the technicalities go smoothly. So I will take up Aidan's point on post-Brexit perspective. So my talk will be, or the title of my talk sounds unphilosophical, and it is forward-looking, but you will see it will become more philosophical as I go along. So it's about the ultimately the self-understanding of the European Union, which is tossed around by crises. Good. I will also upload some slides in a second, and I also warn you to the fact that I'm suffering from hay fever. So if I sneeze, then that is the reason. Good. So next generation EU, German constitutional identity and the meaning of sovereignty and solidarity. So first thing of note is that really a lot of money is at stake. You may even think in terms of a Marshall Fund like after World War II. So in response to the COVID pandemic, European Council's 2020 own resources decision of the 14th December of 2020 authorizes the European Commission to borrow up to 750 billion on capital markets on behalf of the EU. And this requires approval by all of the member states. So there is no doubt that this recovery package breaks new ground. It may not quite amount to a Hamiltonian moment for the EU, a mutualization of national debt the way the United States did through the Funding Act of 1790 under the stewardship of Alexander Hamilton. However, by allowing the EU level to borrow to fund public expenditure, a long-standing taboo has been shattered, and in particular a taboo in Germany, which is, as you know, fiscally conservative due to German experiences in the 1920s and 30s. So the main instrument will be the Recovery and Resilience Facility. So you will meet a lot of jargon today. So Recovery and Resilience Facility, which can call on funds of up to more than 600 billion, of which up to more than 300 billion would be grants and up to 350 billion loans. And as the Commission website has explained, the aim is to mitigate the economic and social impact of the pandemic and to make European economies and societies more sustainable, resilient, and better prepared for the challenges and opportunities of the green and digital transitions. So you notice here already that further objectives are added, namely green and digital transition. And to finance this project, the European Commission, acting on behalf of the EU, will borrow on the markets at more favorable rates than many member states could if they did it on their own, and redistribute the amounts. All member states in turn will be required to prepare national plans for using this recovery and resilience facility, and each will have to allocate a minimum of certain amounts to the outlays to climate change, to deal with climate change, digital investment, and environmental goals. However, in Germany, a constitutional complaint was lodged against the German Act of Approval by a political alliance wishing Germany to leave the EU and certainly also to leave the euro, based on the argument that domestic ratification encroached upon the constitutional identity of German basic law by violating the German parliament's, the Bundestag's, budgetary autonomy, and that the decision to be ratified in any case exceeded the EU integration agenda in a manifest and structurally significant manner. So at this point, I might upload perhaps the slides. Let me see if that how that works. So here, so that should be visible now, I hope. And so that is the constitutional complaint. And let me just go in the in the slides. Here, back to the next one. So this is the recovery fund, and now we come to the German position here. Okay, and the constitutional complaint was firmly couched in the constitutional legal vocabulary supplied by the German Federal Constitutional Court in the past, including its notorious ruling of the 5th of May 2020, where the German court declared the European Central Bank's public sector asset purchase program, the PSPP, ultra vires, directly contradicting the Court of Justice of the EU. Yet, in its order of 15th of April 2021, of which I will say far more a bit later, the Second Senate of the German court rejected an application for a preliminary injunction directed against the German Act of Approval. So the applicants did not have it in the first round. With its decision, the German Federal Constitutional Court has paved the way for ratification of the 2020 own resources decision by the German side. So the German president was allowed to sign that act. However, and there's always a however or a but when it comes to things German, the German court also raised the prospect of a future preliminary reference to the Court of Justice of the EU as to whether the 2020 own resource decision is an ultra vires act. If the German court later in the main proceedings were to conclude that the decision indeed exceeded competences conferred under the TFEU. So in essence, the court says, currently we allow you, Germany, to go ahead. However, if in the main proceedings we find that there is something untoward, then we will make a reference to the Court of Justice of the EU, and as we will see, a situation just as in the PSPP judgment might materialize. So by way of a critical comment on the German court's order and its underlying reasoning and outlook, I want to pose the underlying question of sovereignty and solidarity in the contemporary European Union. For many years, using the term of constitutional identity, the German court has expressed its deep unease with alleged erosions of the principle of conferral as a basis of the European order that also safeguards the budgetary autonomy of the German Bundestag, the German parliament, as an indispensable requirement of democracy in Germany. Yet, in response to the German court's order, I propose in the following to compare two conceptually different, to conceptually opposed perspectives on sovereignty and solidarity. The first one is a statist one and thinks of the EU in the German court's own words as a quote unquote, a union based on the multi-level cooperation of sovereign states, constitutions, administration, and courts. So despite the multi-level idea in that formulation, the starting point is the nation state, the member states. And so the EU is seen as a construct of the member states. The member states are the principals. The EU is the agent. So political science people will say, oh, this is principal agent analysis. The second perspective, by contrast, thinks in terms of the EU as a constitutional polity and of geopolitical Europe. And here, of course, is some uncertainty in the vocabulary and in the concepts themselves, because it is a position which is not clearly staked out, but is in the process of being developed. The new concept of the EU's open strategic autonomy, so that is a new concept, has emerged. And it derives from concerns across a number of domains in the EU about dependence on others, other countries, power blocks, and a lack of influence on global affairs commensurate with the EU's economic weight under the condition of heightened uncertainty. That condition shapes how sovereignty is to be understood as it becomes clear that in a global order, also modern nation states themselves suffer from an intractable democratic deficit, with the consequence that they can no longer be seen as the principles. So the journey goes here, and from the second perspective, in the direction of saying that it is only at the EU level that we can safeguard what we deem valuable in the national constitutional welfare state. Good. So I will proceed in 3 steps. First, I will introduce you to the concept of constitutional identity and the self-understanding of the German Constitutional Court as an activist court. Secondly, I will tell you a couple of things about the recovery package, Next Generation EU, and on the German court's order of 15th of April. And finally, as I warned you, I will become a bit more philosophical again. I will address the normative democratic question. And that is where my own interest here comes from. Good. So let us start with the emergence of constitutional identity as a concept. And it may be slightly disingenuous of me if I put it in connection with a sociological phenomenon of Euroscepticism from the political center. So that is not Euroscepticism as you know it from the far right or far left, but from within the very center. And the view that social democracy implies the nation state. And here, when you look at recent polls by the European Council of Foreign Relations, for example, more than 50% of French, Germans, Italians, Spanish said that they thought the political system of the EU was broken rather than working well. And only 46% of German respondents and just 38% of French said it was a good thing for their country to be a member of the EU. And that, of course, makes you think. Now, leave that just in the back of your minds because I will now focus on constitutional identity as a legal concept. And initially that emerged in the context of fundamental rights. And at the core is a perfectly legitimate and important and urgent question. Namely, what is a national constitutional court, which has ultimate responsibility for ensuring the rule of law, fundamental rights, and the principles of democracy within its jurisdiction to do when faced with an EU measure which in its view violates such? And what should that court do when a judgment of the Court of Justice, the guarantor of all those values within the sphere of competence of the EU, legitimizes that EU measure in a way which the national court regards as inadequate, or at least not reaching the level of protection required by the national constitution? And these questions are not purely academic, because national constitutional courts will say, well, we are the guarantors of, say, human dignity in our constitution and of fundamental rights and of equality, etc. What happens when the protection of fundamental rights offered by the EU and the Court of Justice does not meet the standards which would be given by a national court within its jurisdiction? Good. So we know, of course, that there is the principle of supremacy of EU law, and we know why it exists. And at the same time, however, one can understand that a national constitutional court can justifiably believe that it cannot stand aloof when the rights of one of its nationals, the national constitutional rights for whom it is sworn to protect, are about to be violated by an EU measures. So this has been a long-standing debate about which I will not say much here. And however, such discussions which arose initially from German court rulings asserting its retained competence to review the compliance with fundamental rights against the requirements of the German constitution. And here you know the story about the as long as, the Solange jurisprudence, which I just bring to your minds. But without going into detail, be aware that this is a very real and burning question, because it's not only a shortfall of the EU in terms of fundamental rights protection, but also the phenomenon of reasonable disagreement about what should count as a adequate fundamental rights protection. Let me give you two very brief examples. You know all the story about the European arrest warrant, the Meloni case. Can you convict somebody in absentia? Is that compatible with Article 47 of the Charter? You might say yes, if everything has been done to inform the accused of a trial. But you might also say no, because there is a categorical argument against that, as the Spanish Constitutional Court and also the German Constitutional Court argued. So that already illustrates the possibility where you have a reasonable disagreement on both sides, or in cases about the meaning of the term genuine, legitimate, and justified occupational requirements in one of the directives. Does determination of the meaning fall under the privilege of churches, of faith-based organization, or can that be juridified by the Court of Justice through extension of proportionality analysis into that domain? So these are examples of reasonable disagreement which are rife throughout EU law. However, now the point is, the structural dilemma is even more acute than fundamental rights, human rights, when at issue is the issue of delimiting the competences, the respective competences of the EU and its member states. After all, the European Union derives its competences and powers by a delegation from the member states, as enshrined in the treaties. And is it not, you might ask, at least partially a matter of national law to define what could constitutionally be delegated? So that is arguably a deeper question. And if you look now at the slide, let me just look myself at the slide. Here you see here the development of that argument. So in the Maastricht judgment, the court, the potential scope of review was extended beyond fundamental rights to cover the review of the union's exercise and of competence more generally. Then, in its Lisbon judgment, finally, the court examined whether the inviolable core content of the constitutional identity of the German basic law is respected. So here this topos came to play. And under the title of identity review, the court has named core areas of such statehood, namely of statehood, the control of which must remain in the national at the national level, including, among others, the democracy principle, the rule of law, and human dignity. And so, of course, the problem which comes with this identity review, and I will illustrate this when we move forward and come to the next generation EU project, is that nobody quite knows what identity means. I mean, ask yourselves, what is my own, what is your identity? Yeah, it is not an easy question to ask, and certainly not when it comes to a constitution. And it is, however, the sole prerogative of the German Constitutional Court to say what German constitutional identity here means. So, and there is a risk, of course, that this is exploitable to promote political agendas, which ultimately undermine the effectiveness and unity of EU law. And perhaps a final background issue here, a judgment which I want to draw your attention to is the following. Let me just hear the Honeywell judgment. And that is quite striking because it illustrates that the relationship between the Court of Justice and the Constitution and the domestic constitutional courts, the German one, is anything but rosy. So on the first, you have the idea that any conflicts must be harmonized cooperatively in accordance with the European integration idea. And the German constitution is open towards European law, so it's Europe friendly. And the European Court of Justice develop the law. Yeah. However, the final sentence, but the Court of Justice has a right to tolerance of error. So suppose somebody says to you, very well what you do, but you have a right to tolerance of error. I mean, that could be perceived as pretty patronizing and a slap in the face. And that shows that the relationship between both courts is tense. And I should also know, for you to understand more about the specific order I will talk about, um, um, briefly, let me just go back to the slides, introduce you to three provisions of the German basic law. So Article 20 of the German basic law, essentially saying that all state authority derives from the people, and Germany is a democracy. Then 23, the emphasis on united Europe. So that is already, for those who are UK citizens, should be interesting because you have EU membership written into the written constitution. And participation in the development of the European Union, etc. And then finally, 79 is important because that is the so-called eternity clause. And the eternity clause means that certain provisions, such as fundamental rights and Article 20, cannot be changed. They are there for the eternity. And the upshot of what I've been telling you so far under constitutional identity is that this concept is positioned against the European Union, against the European integration process. So there is a constant threat or perceived threat that European integration must be or encroaches upon the constitutional identity, which is put in here defensively, and that the eternity clause is at stake. So that is quite important. Good. Now the next further step is to be taken for you to understand the order, which I will focus on fully in a second, namely, how is it possible for individuals to bring an action against any EU act, for example, about the budgetary autonomy of the German parliament at all? And how can this constitutional identity argument be mobilized by individuals? And here is a striking pathway which the German court created by relying on the right to vote, the individual right to vote. So under the German basic law, only individuals whose constitutional rights are at stake have standing to bring a constitutional complaint before the court. Such a violation of the individual fundamental right, however, appears hardly self-evident when, for example, in the case of PSPP, it comes to the central bank policies, or in the context of the next generation of the EU. So the idea is the budgetary autonomy of the German parliament is read into the individual right to your individual fundamental right to vote. So any threat to the budgetary autonomy of the autonomy of the Bundestag becomes actionable through the argument that your individual right to vote is endangered. Yeah, and that, of course, so it means the idea is the German court here actively invites and even encourages litigants to initiate these legal actions in order to protect the holders of the right to vote from a loss in substance of their sovereign power. Just any transfer of rights to the EU that is not explicitly endorsed by the German Bundestag or that might affect its budgetary autonomy now becomes challengeable as a violation of the individual rights to vote. So what you see here is a development in which the German court provides the vocabulary for plaintiffs, such as this far right-wing group here, to go before the German court and say, well, the German constitutional identity is being infringed because money is at stake, the budgetary autonomy of the German Bundestag. And the German court encourages this. And ask yourselves, how democratic is this? But it is sort of an ongoing process. So the locus standi is here expanded. The locus standi for citizens is expanded, and in this way, and clearly the concern is here that there are further considerations at stake, namely the concern about a possible loss of control. The German court seems to suggest that democracy can only be based on a nation state by virtue of Article 20, and that the German constitution introduced strong and protections through the eternity clause against the EU. Good. So with this now, without further ado, let me move to the EU recovery package. And here, let me just go to the so right to vote and recovery package. Good. So here, as I mentioned before, the German court had rejected an application for a preliminary injunction directed against the German act ratifying the EU own resource decision. Bear in mind first that the German Bundestag had already made its peace with the recovery fund. 645 MPs cast their vote. 478 voted yes, 95 no, 72 abstained. So there was a large, more than 2/3 majority for the act of approval. Now, what were they approving to? What does this recovery fund actually do? Keep in mind here, it is based on Article 311 of the TFEU, the Council acting in accordance with the special legislative procedure. You can read it yourself. So that is the basis. And good. And so the objective is here, so it authorizes the European Commission to borrow, as I said before, and to use these monies for expenditure. And however, there's a strong emphasis on limitations now and on financial certainty. So first of all, if you you will see that there is here the when you look at the council decision, which is relevant here. So support should be limited in time and the majority of the funding should be provided in the immediate aftermath of the crisis and should be made by 31st of December 23. And to bear the liability, there is the ceiling for appropriations and for payments, and for the ceiling for appropriations for commitments should be increased. So the ceiling for the own resources should be increased by 0.6 percentage point of the gross national income of the EU 27 states, so to provide certainty. All funds borrowed have to be repaid by the 31st of December 2058. And new net borrowing activity should stop latest by the end of 26. And the repayment of funds should be through the EU budget, and of course then through the member states. And importantly, the Union should not use funds borrowed on capital markets for financing, for the financing of operational expenditure. So that is very important, because the idea is not that member states now become liable for each other's debts, but it is merely focused on here on the pandemic. Good. So now the implications are here of this as follows. Investments will have to be targeted to fit into the narratives constructed in partial justification of the NGEU. And so there have to be also to be met rule of law provisions. So the rule of law conditionality is built into this, and specifically with regard to Hungary and Poland. And I can say more about this in the discussion later. And then the emphasis on green, so on green initiatives and on digital initiatives in the spending of these funds. Good. Now, the German court here, confronted with this, reiterated its core jurisprudence, and here saying here the right to self-determination as derived from etc. protects citizens not only against a substantial erosion of the parliament's latitude to shape policy, but also affords them a right that institutions, bodies, and offices and agencies of the European Union only exercise the competence transferred to them in accordance with Article 23. And so the point is here that the German parliament is still able to take all essential decisions on revenue and expenditure. So there is an idea of no taxation without representation. Yeah, all essential decisions have to remain with the, and also the court then, however, felt that the threat to the budgetary autonomy is not overwhelming, and essentially gave here the green light, arguing that the Bundestag is not being deprived of its decision-making prerogative. And good. And I mean, there were certain factors which I can also come in the discussion afterwards, bring in. So in the end, the court here struck a balance between the threat, what would happen if this did not go forward, namely the whole project would collapse, the next generation project would collapse if Germany could not participate. And clearly the court was shattered by the very negative response to the PSPP ruling, but it kept itself the door open for main proceedings. So it did not dismiss the proceedings at the present stage, but said we want to revisit that. So there is further jurisprudence to be expected and a further clash with the Court of Justice of the EU to be expected. Good. So with this, let me come now to the third issue, the conceptions of democracy. So first, as I said, it may make sense to distinguish two of them. Namely, first, there is a statist view that democracy implies the nation state. For normative reasons, the nation state is seen as the locus of social justice, as this is where democratic agency, democratic participation, and will formation take place, and where distributive politics and an expansive fundamental rights jurisprudence can be accounted for and legitimized. And there are two versions of this statist view. One is in the ordo-liberal tradition. So ordo-liberal, this is a technical term, which says that supranational EU law is or defines a sphere of open markets, whereas social policy remains vested in the nation states, but only under conditions of open markets. And the opposite view of these two views is the social democratic one, which points to the constitutional asymmetry between economic freedoms at the supranational level and social policy in the EU construct, and bemoans the encroachment of the former into the proper domain of the latter. Second, however, there is a democratic experimentalist view of the EU as a polity and global actor. The normative underpinning of this view is the assumption that the normative substance of the modern European social democratic welfare states can, under contemporary circumstances of world politics, only be defended and developed at the EU level, but no longer exclusively at the domestic level. And that perspective clearly is in tension, in conflict with the perspective of the German Constitutional Court, which domesticates democracy. And in this connection, a new term has entered the dictionary, namely the open strategic autonomy of the EU. It derives from concerns across a number of domains about dependence on others and a lack of influence on global affairs commensurate with the EU's economic weight. These concerns manifest themselves notably in vulnerabilities in the exercise of power by global rivals. So this concept was given prominence already in various documents, and together with another one of these neologisms, which you might find awful, but it's tellingly awful, so to speak, principled pragmatism. Yeah, I mean, it's like squaring the circle, like kosherring the pig. Yeah, it is a term which brings two opposites together. It's okay. And the concept starts with a desire to be able to act independently of the global superpowers, but also implies the EU becoming such a power itself, translating into aims for increased, now quote unquote, efforts in defense, cyber, counterterrorism, energy, and strategic communications. Motivations include disquiet about the United States, that the United States has weaponized its pivotal position in the global financial system, alongside fears regarding China's Belt and Road Initiative and the etc. So at issue here is how Europe can manage and respond to globalization. Good. And to conclude now soon, so at first glance, the open strategic autonomy sounds like a contradiction in terms. It implies wanting to promote openness in trade, yet also wanting to promote or favor domestic producers. In this instance, those inside the EU at the expense of foreigners. And this is, there is an idea of shaping the new system of global economic governance and developing mutually beneficial bilateral relations while protecting ourselves from unfair abusive practices. I mean, this is again a quote. So you see here, there is an unresolved tension between, on the one hand, the focus on global competitiveness versus, on the other hand, the denationalization of the European social model. Yeah. And where the Next Generation EU program fits into this is not altogether clear. The financial capacity of the EU will increase by 70% through the NGEO program, yet the legal construction is sharply depoliticized. The EU is used here as a special purpose vehicle to provide member states with funds. This may in fact not strengthen but threaten the self-understanding of the EU as a polity in its own right, because under Article 311.3, the EU Parliament, for example, has no role in deciding on the expansion of EU financial capacity, nor in influencing the expenditure of the way money is spent. So there might be even an element of democratic regression in this design. And it might even dovetail with the ordoliberal reading of the EU construct. So to conclude, the NGEO is a high-risk gamble. If the plan succeeds, it will surely pave the way into further initiatives and perhaps ultimately to fiscal union alongside the monetary union. But if the plan fails to deliver on stated goals, if political interests prevail over economic necessity, federal aspirations will be dashed for a generation. So all in all, it epitomizes the usual dilemma of the EU, namely deep disagreement about its values and how we should understand them. Thank you.
Thanks very much, Oliver. That was astonishing tour de force, and raises, gosh, so many questions that one would like to deal with. And I mean, there are quite. I mean, there are all sorts of things I wanted you to talk more on, and clearly one has a limited time for it. But you mentioned in passing that you would speak more on particularly rule of law issues and Hungary and Poland, and the kind of issues that might arise there, given the rule of law concerns, which are clearly coming to the fore. So could you expand on that a bit, at least for my interest?
Yes, yes. I mean, that is what the EU here has done, is a kind of fudge, and then which materialized in December 2020, because of course, I mean, the EU and many of us are concerned about what is happening in Poland, and in particular Hungary, and in particularly now what is happening. I mean, you will all have heard about the story about the games in the football in Munich, and the stadium, and the UEFA argument about neutrality. I mean, this is all puzzling and irritating. So the EU wanted to make sure that there is a rule of law conditionality here, essentially saying you only get money if you comply with rule of law requirements. And of course, there is a long-standing jurisprudence by the Court of Justice on this issue, and there's also Article 7 of the TEU, etc. So that is a concern. But Hungary took the position here that, well, if you insist on that, we will not agree to this project, and meaning that the EU, this project would have been left in limbo, and the EU would probably have to seek the way of an international treaty to realize this. Under the fudge is as follows. So under the new plan, the European Commission will refrain from implementing the legally binding rule of law mechanisms while a member state challenges its legality at the Court of Justice. So this clearly is a fudge, a kind of Machiavellistic fudge. I don't know if this goes together, Machiavellistic and fudge, but it is a strategy which allows to temporalize the conflict, because this is a process that can take months, even years. So that is, but it illustrates the deep conflictuality of the EU, and that much of its rhetorics about being in the Charter, about being on the forefront of fundamental rights and non-discrimination, etc. And think of Article 21 of the Charter of Fundamental Rights on non-discrimination. That all this is that, let's say that the EU's hands are tied when it comes to putting that into practice. And if the EU cannot put it into practice, cannot enforce these commitments, of course, its legitimacy will suffer, because everybody will say, oh, the EU is unattractive, it is weak, etc. It doesn't really stand for what it claims to stand.
So, I mean, at some levels, then the problem seems to be the idea of unanimity being required of the nation states, as clearly would be required of the member states in any treaty amendment and in these matters. So, taking the broader view, because the EU has only existed for 60 odd years, or it must be more than that. I'm 60. So 70 years. I mean, clearly the giving up on unanimity
yes,
was a major step. Is that the way forward then? That one, in a sense, gives up on unanimity, and thereby the individual member states no longer are the monads, the starting blocks for one's analysis of the EU and how it goes forward. I mean, basically, have we to bypass Hungary?
Yes, I mean, that is, I mean, yeah, I can only speak speculatively, but there is indeed, in response to these to these concerns, to these problems, a talk about a new convention on the future of Europe, and so a convention which which the idea of which is a conference for the future of Europe, to give up the idea of unanimity, and to allow qualified majority voting to go to become the main principle, and so to create a new political compact in the EU. So a convention on the future of Europe, that is called, and this is sort of the big thing, because of the limitations of Article 48 TEU, and so for that reason, this is whether this is a way forward is I'm myself conflicted about, and I do not know the answer. Of course, it is a way, as you say, of bypassing Hungary and Poland, and to avoid resorting to international treaties. Um, um, However, there comes a risk, because it might lead to the dissolution of the European Union in the long term, and if member states can be outvoted, and if there is no overarching consensus. And keep in mind that these countries like Hungary and Poland are themselves divided countries. They are not just black boxes, or black in every sense of the term, but they are divided. And the alternative strategy is to try to appeal to the liberal voices in these countries in order to instigate progressive development, although that may be fanciful. But I do not have a straightforward, clear answer to your question here. I think nobody has, or at least perhaps you have.
Luckily, in this case, I get to ask the questions, not provide the answers.
Yeah.
Another time, though, one of the things that struck me as a practicing lawyer, where you seem slightly critical of the idea of standing, locus standi, having been expanded apparently by the FCC, and that you said, and it's now allowed and encouraged these far right groups to raise difficult questions. I mean, in my own career, I have been one of my main for 30 years has been trying to push open the doors of the court to allow for greater standing, and that has happened. The UK now has incredibly liberal rules on standing, which I have always thought of as a good thing. Not in the sense of it allows questions still to be asked. But you seem to be suggesting you thought it's not a good thing to have broad rules of standing whereby difficult questions are put forward by undesirable, apparently undesirable political entities. But do you have a view on that?
Yes, I mean that's a very good question. I mean, let me just say generally, I too am in favor of liberalizing locus standi, and I very much sympathize with the argument by Sir Francis Jacobs many years ago, who proposed that in the UPA litigation. And I think there can be a democratic element in opening up locus standi. In this case, however, this is a very specific case here, because it is a far-fetched construct. What is at issue is the worry about money, the worry about the budget of the German Bundestag, about the fact that about Germany having to pay the debts of other countries, and the sense that Germany is too big for the European Union. Yeah, that is sort of the mentality, and that argument becomes legally legible now through this construction, which ties the budgetary autonomy of the Bundestag to Article 38 of the German Constitution, the right to vote. I mean, would you have thought of that your right to vote is being undermined through, say, the PSPP program, or say through the next generation of the EU? I mean, that is a bit of a stretch. And my suspicion here is that, or concern here is that there is a kind of collusion, between the German Constitutional Court on the one hand, and those Eurosceptical groups on the other, where the German court sort of constantly provides opportunities for them, for these groups to challenge the European project, even where the German parliament has long made peace with it, and where even German society has made peace with it. So there is here a concern about political influence. And now back to your question. I would say locus standi can be a good thing when it is expanded, when it comes to to the core domains of fundamental rights, when it comes to fundamental social rights. Yeah, but here in this context, I feel skeptical, because I see here this phenomenon which I described at the beginning of my talk as Euroscepticism from the center. Yeah, and that is something which deeply worries me. So, for example, when you read Dieter Grimm's work on I mean, you know the name. I mean, he is a very well-known German constitutional lawyer, and the first sentence in his book is European integration is a necessity, but every other sentence in the book says why it cannot work and why it is a bad thing. So there seems to be a situation where German support for the EU is wavering, and this jurisprudence by the Court of Justice seems to be deeply political by providing an influence here, which is to certain groups in society, which they de facto perhaps do not have. I mean, the far right and the far left often acting together, yeah, like in the pincer movement. I don't know if this. Yeah.
Of course, I can understand those concerns, and at some levels, I used to be very blithe and blasé about the idea that a small ginger group, as in Eurosceptics in the UK, were never going to have any major influence, and therefore, in a sense, it was at least a good thing that there were a possibility of letting off steam by going to court and arguing hopeless cases. There were quite a number of cases by various people in the UK in the 70s and 80s. Norris McWhirter, William Rees-Mogg, in fact, the father of Jacob Rees-Mogg. And they were challenging, this is contrary to our constitutional fundamentals, the idea of ceding even conditionally any kind of sovereignty. And I thought, well, that's fine, at least they've had their day in court. And of course, there were useless arguments. But you're right. I mean, frankly, I had no idea that ultimately that Euroscepticism would come to play the place and the power in the popular culture, which it subsequently has. So perhaps your more cautious approach, that as compared to my blithe optimism on the idea of robust dialogue is always a good thing. Perhaps you're right on that, but certainly history seems to be on your side rather than on mine, perhaps.
That's rare, though.
Oh, I think we've now reached the hour allotted. I don't know if there's any more questions which might arise. So I'll just at this point say thank you very much, Oliver. That was a fascinating talk. I really enjoyed it. I thought it raised so many questions. I would really appreciate if you were to create a paper out of this. I think it was. It's incredibly timely, incredibly important, and you know, it's about the future. So thanks very much for looking into that for all of us, and you know, I look forward to reading more on this and hearing more from you on this. So thank you, and thanks to UCL, and thanks to everybody for having tuned in and listened to this fascinating hour of where we're going.
Yeah, no, I mean, thank you to you, Aidan. I mean, for your questions and challenges, and I mean, we definitely need to get the discussion continuing, have it continuing, and to deepen this discussion, because I can learn from your experience as a practitioner, and so that's and I mean, we share the theoretical concerns. So that was very helpful, and thank you for attending, and thank you to the audience, to everybody for having been here and for listening to me. At the end of an academic year, we are all half dead, and I feel I'm only a teaching automaton and a bureaucrat these days, and so it's good to come back to have 1 hour of ideas and discussion. And thank you, Aidan, for having joined us.
Absolutely. Thanks.
Okay, thank you very much. That was